another?
May it please the court, my lord, I appear for the state in this matter with my learned colleague, Mr. Singh.
Thank you, Mr. Dana.
As the court pleases, my lord, I appear together with my learned friend, Mr. Kulu, on behalf
Yes.
of the first accused.
Thank you, Mr. Woodlazy. Thank you.
May it please the court, Ms. Jackson, I appear on behalf of the second accused.
Thank you, Mr. Roo. Yes, what's happened in the interim?
My lord, let me inform the court accordingly.
Yes,
I checked with the registrar of the SCA
right.
twice, and it is confirmed that there is no result yet from the SCA in respect of the Section 17(2)(f) application of Mr. Zuma's. So that brings us, my lord, with
I
respect...
was a bit surprised because it's from the 11th of April already, and normally these matters are dealt with fairly quickly. Did you perhaps confirm, or can you confirm, that as much as it was filed, when I say it, the application was filed with the registrar, we've got the stamp, has it been confirmed that it's made its way to the desk of the president?
The last message I received from the registrar was that it was on its way to the president. The reason for the delay is unclear to me. It's not our mandate to interrogate that.
No, of course.
But it has been received. The papers are ready, and they are on their way to the president.
And when was that, Mr. Dana?
It was yesterday.
Yesterday.
Yes.
So yesterday it was on its way to her.
Yes. And my lord, your lordship will be aware that because your lordship was copied in the correspondence, that we did not file an answer precisely to speed along the process.
Yeah.
And we urged that the matter be speeded up.
Yeah.
So we did, with respect, what we could from our side to make sure that we did have a result today, but be that as it may, we don't have a result today.
Well, the reality is, as you say, we don't have a result,
Yes.
and we have to await the result.
Indeed, my lord.
Yes.
So that
what has
brings us
been-
into paragraph C of your lordship's order
Right.
of last month, and that the court said that if the reconsideration application has not been disposed of by the holding date, that's today, then a further holding date and date for the continuation of the trial shall be determined on the holding date. So that's where we are now. And my lord, I have consulted with both my learned friends, Mr. Mpofu by telephone, he's not here today, and also Mr. Buthelezi is here today, and I've also consulted with Mr. Roo about what dates are we then looking at. We thought, obviously, subject to the court's ruling and the court's view of the matter, we thought that it makes no sense to keep the holding date of the 31st of May because it's a mere 2 weeks from now. And
Well, that was the intention was if the application had been disposed of by today, then it would give 2 weeks to allow, amongst others, the second accused representative to come back for the trial to continue.
Indeed.
But obviously that scenario is now, what was contemplated isn't achievable.
it's not achievable, my lord. So,
Yes.
so we thought that on any realistic view of the matter, we are not going to start the trial in this term because the term ends on the 18th of June.
That's right.
And so even if we were to come back on the 31st of May, we'd still need a couple of weeks to get our ducks in a row. And there might be applications and all sorts of things. So we thought then that we all agreed that we're not going to set a trial date this term and that it makes sense to propose, subject to your lordship's view of the matter, a holding date, the next holding date, in accordance with paragraph C of the order, of the 14th of June. That is the last week of this term. So by then we ought, for some considerable time, to have had an order from the SCA, whichever way it goes, and that will then give us sufficient time to decide what our approach will be on the 14th, whatever applications there will be. But then we agreed on that. We all agreed on the 14th. That is a Tuesday, the last week of this term. And
Let me
that
just check my
leaves-
own availability on that, sorry. Yes.
So that your lordship will then determine that. But that being so, we thought realistically the first date that the trial could possibly begin would then be the first date of the third term, which is the 18th of July. 18th of July. The recess ends then, and so that Monday, the 18th of July, is the notional date for the continuation of the trial, in accordance with your lordship's order, paragraph C.
Yes.
And we are already booked for the third term and the fourth term.
Well, there's a point that's going to be raised by Mr. Roux about
Yes,
that. Yes.
I'm aware of that. So Mr. Roux has again drawn my attention to that, and he's not available for the whole of November, basically. Yeah, the 3rd of October to the 4th of December. Sorry, he's not available. 3rd
He's
of
not
October.
available in October, I think it was.
Yeah, from October, 3rd of October to the 4th of November, indeed.
Yeah.
Yes. So we've taken that into account. So that being so, we would sit for the 3rd term, and then not the 4th term up to the 4th of November, but to start after the 4th of November to the 4th of December. So if the court is disposed to grant Mr. Roux's request that he be released on those dates, then
Yes.
those would be the dates, and that then takes a chunk of time out of the 4th term. And so I propose that we look at the 1st term of 2023, because the trial is not going to be concluded in those shortened terms of this year. And Mr. Roux then drew to my attention that he's not available the 1st term.
First term of
Of
23.
2023. So then the order your lordship could consider making the order that the 2nd term be booked. And my lord, Mr. Mpofu did raise with me, well, why are we booking trial dates now when the progress of the matter is not certain, depending on what happens in the Constitutional Court? And I said I would imagine that the best argument is that we have to keep council diaries open, so that if we
Yes.
get to a trial, we're not looking at yet another year's delay.
Well, that's another issue, the days, because it also runs into some other difficulties that I have personally.
Yes.
But firstly, I just want to find out where, we've got this application at the moment in terms of Section 17(2)(f), the reconsideration application. Obviously, if it's granted, then we're into the Supreme Court of Appeal in some form of hearing there and appeal. If it's refused, then the indication has been that there'll be an application for leave to appeal to the Constitutional Court.
I think, my lord, gathering from what I've discussed with my learned colleagues for accused number 1, that would undoubtedly be so.
Yes.
No, naturally, I can't speak for them, and naturally,
no.
They can't make up their minds until they've.
Yes,
they've
I'm
seen
just
the
wondering
evidence.
whether, instead of making it the 14th of June, we allow the recess period and a bit more to run on that. And we have a holding date of the 1st of August. So to allow the time in the interim, obviously if the reconsideration application is dismissed, then I think, if I recall correctly, the Constitutional Court rules require an application for leave to appeal thereafter to be brought within 15 days.
15 days, my lord, yes. And our answer 10 days after that. So,
Yes,
yeah.
but at least then one will know whether such an application is being pursued. I know you've indicated, and obviously you can't speak for Mr. Buthelezi, but that's always been what has been said, that
Yes.
such an application will follow.
Yes.
It might not. Look, there was an application to the Constitutional Court in the permanent stay application
Indeed, my lord. Yes.
that I think was eventually not pursued or abandoned or whatever might have happened. Shouldn't we allow until the 1st of August as a holding date, so that that part of it can also be hopefully resolved one way or the other as to whether such an application is being pursued? And then if we make it the 1st, if by the 1st the reconsideration application has been dismissed and there's no application for leave to appeal to the Constitutional Court, or even if there might have been, it's possibly disposed of. I don't know whether it'll happen so quickly, but nevertheless, that the other date for the trial to continue would then be the 15th of August.
Indeed, my lord.
Just to avoid
Yeah.
coming back to court
Yeah.
again, because if the matter is now properly on the desk of the President of the Supreme Court of Appeal, then I would anticipate that some sort of decision will be issued without putting her on terms, but that it's some decision or determination will be made pretty shortly.
My Lord, I'm in the court's hands. Naturally, the state is dismayed, as I indicated at the last application, with the length of the postponements, with the effect on the administration of justice, etc., etc. I could stand here and make an argument
Yes.
that it's all too much and that it
Yes,
should
no,
be shorter.
I'm very alive to it. I'm also concerned about the delays. I'm also concerned about delays not only in the interest of the administration of justice, but also the accused, particularly accused number 2 in this
Yes.
matter. And I don't want to cover ground that I've covered before, but it seems to me that we now, with the reconsideration application and procedures to follow thereafter, squarely, whatever doubt there might have been before, within the parameters of the Superior Court Act. And as such, Section 18 says that the decision is, or the process is suspended. I don't have a discretion in the matter. So all we can do is sit out this process of further appeals or further applications along the path of appeals. I can't affect that in any way. Obviously, it must just be pursued in accordance with the time limits and the rules of court. And obviously, in the light of the judgment that my judgment in on the
Postponement application.
the special plea,
Yeah.
the special plea, I don't believe there's any substance
Exactly.
in these processes, but whether I believe there's substance in it or not, the provisions of Section 18 of the Superior Courts Act bind me. And whether that might be amended in due course, as I think I suggested last time, that's a question of legislative reform. It's not within, not in my hands.
Yes, my Lord. Your Lordship has already ruled in that respect,
Yes.
and we argued to the contrary.
Yes.
We said your Lordship does indeed have a discretion, and,
Yeah.
and the matter could be shortened
Yeah.
in accordance with the arguments then, but your Lordship has given the
Yes.
ruling.
Yeah.
And that being so, we're now in precisely the sort of situation that we didn't want, that we wanted to avoid by urging your Lordship as we did previously. But the judgment has been given.
Yeah, that's how I understand the legal position, and obviously I'm bound by my oath of office. And there it is. We will have to entertain these processes. They form an important part of an accused right as well.
Yes.
And I think let's just manage the process.
Indeed, my Lord.
What about the 1st of August then, and the other date to be the 15th? And then we can talk about, if that's in principle acceptable, then we can talk about the future progress of the matter thereafter.
Indeed, my Lord.
Obviously on the basis that the reconsideration application is unsuccessful, and any application to the Constitutional Court thereafter is likewise successful, because otherwise it will just push the whole process out.
And I propose, subject to what my learned friends say, obviously, that we agree to that.
Yes,
I would imagine that from our side, from the state side, we would try to, through correspondence and with my learned friends, to reach a situation where we are certain about a trial date,
yes,
that it's actually going to run. Because your Lordship will know that twice now we have been about to start the trial, which involves
Yes.
arranging witnesses to fly in from all sorts of places.
well, that's why I've had these holding
Yes.
dates now, so you don't bring people out.
Yes,
Yeah.
no, indeed, my Lord. But so that we will ensure that when the trial is due to start, it actually starts.
Yes.
Because we can't afford, for everyone's sake, to allow that process to happen again. That we're all geared up to go with great expensive money and inconvenience, etc., and that it happens yet again for a third time. It simply
Yes.
cannot be allowed to happen.
Yes,
So with that, and we would also urge the court, even at this stage, my Lord, that this can't happen every time there's some order by the court during the trial, that matters are taken up and down the superior courts to challenge those orders. And we would think that if we win in the SCA and in the Constitutional Court, that might resolve to some extent the issue of interim appeals, and that your Lordship would then be happily bound, because your Lordship has already found that, but would then have the authority of the higher
Yes.
courts.
yeah,
That
we will
is
have
the way forward.
to deal with that as
Yes.
and when those kinds of applications arise. obviously in the light of what the SCA or the Constitutional Court might or might not say.
Indeed.
You might not get the guidance that you're hoping for
Yeah.
if the applications are simply dismissed.
Yes, but then at least your lordship's orders would have been confirmed
Confirmed, yes.
for whatever the reasons are that are given in the judgment, which is have a short,
Yes.
or an order, which is simply such.
Well, let me just hear from the other council about this, the 1st of August and then the 15th, and then we'll deal with the question of the dates thereafter.
As a pleasing court.
Okay. Mr. Buthelezi, you've heard
As
the
court pleases,
exchange.
my lord. Thank you, my lord. Yes, we have. We think the holding dates of the 1st of August is pragmatic, my lord. We're grateful for your lordship's guidance
Yeah.
and leadership in that regard. And I think to then have the matter reconsidered following with the 15th in mind is sensible,
Yeah.
my lord.
If it's all resolved by the 1st of August, then people will have, well, teams will have their 14 days within which to, or will have 14 days within which to bring witnesses and bring representatives from France
Indeed, sir.
back again for
Indeed,
the
sir.
15th, and the trial can kick off on the 15th.
We have no issue with that.
Yeah, if it's not, then we might have to look at another holding date, but let's be optimistic that hopefully we can get this trial going.
Thank you, my lord.
Yes. Very well. Mr. Roux, firstly, just on those dates.
I was not sure that Mr. Buthelezi would agree with the optimistic part of that. Peter doesn't. My lord, we have nothing to add. I think it's sensible to have the 2 dates, as long as you've taken notice of the difficulty that
Yes.
we have.
Yes.
We've been ready every time for trial. We're
Yes.
still ready for trial. So it's a juggling process that we're involved in order to
Mr. Roux,
move matters on, and then it doesn't come on.
yes. Look, the reason I've been keeping the future dates or referring to them as well is to avoid a situation where one doesn't reserve these dates for the future.
Yes.
And then a point is reached where the SCA or the president of the SCA or the Concord might have reached a certain decision by August, and you then say, well, when can we have the trial? And then everybody's not available until
Yes, no.
the end of 2023. But I also am very alive to the fact that it's very invasive of your program or your own diaries.
No, I know you do, my lord.
So I certainly want to accommodate it. You're not available during the period from, 3rd of October to the 29th of October. Is it?
No, till the 4th of November.
Is it the 4th of November?
4th of November.
Let me just see.
I may have had the date wrong in the beginning when I checked
Yeah, I'm just going on the letter from
Yes, we
Herbert
checked
Smith.
the date. It's actually the week thereafter, my lord.
Is it? Okay.
I apologize for that. Yeah.
No, it's okay.
And then in the first term, it's from
So it'll be then, you'll be available again from it's Monday, the 7th of November. So if it was to run from the the 15th of August, it would be from the 15th of August until the 16th of September. That's the end of the 3rd term. Then there's a short recess. Then you're not available. Then you're back on the 7th. So then it'll start again from the 7th of November to the end, before the December recess, which is the 2nd of December.
Yes.
All right.
And then my difficulty is in the first term, I had to move a case there.
All right. So
Not anticipating we would, in 2023, still be busy with this
all
matter.
right. So then thereafter, we're looking at the second term
Second term.
of 2023. I wonder on that, Mr. Roux, whether council shouldn't perhaps just let me have a letter from each, from the council that will be appearing at the trial, by the 1st of August, indicating which dates they are available or not available during 2023. And then by the 1st, I can hopefully take all that into account. Or earlier, if you can let me have it in 2 weeks' time or 3 weeks' time. And then we can see what dates, even if we have to take a little bit here and a little bit there, we can deal with in the second term of 2023. Mr. Buthelezi, how does that sound?
I'm in my leader's hands, my lord.
Yes.
So they'll be the ones who determine that. But
Well, that's what I anticipate. That's
Yes,
why I'm
yes.
saying, if
But-
I require them to, within, say, 3 weeks.
they can. We'll convey the message, my lord.
Yes.
One message that's just come through now, Mr. Mpofu is just indicated that he's got a challenge in the week of the 15th of August. And he's asked that we move it to the 22nd. I've canvassed the point with Mr. Downer. He's not happy, but that's what Mr. Mpofu has requested, that both our leaders, Mr. Mpofu and Masugu, have challenges in the week of the 15th of August, madam.
Well, how did that arise? Because I asked that that be kept open.
That's the question Mr. Downer has put to me.
Yeah.
myself.
See, that's the difficulty. If we start, people wanted to, well, today's date also, if I recall correctly, was a date we eventually chose because Mr. Mpofu wanted it. But anyhow, you know, it's a difficulty now. How did this now arise? That, do you know?
Well, he seemed...
Because the court order was clear that it was, these dates were to be kept open.
I don't know the reasons, my lord. I wouldn't miss.
And it's always been the second and the third term. I took Mr. Rue a little bit by surprise, I think, last time, because without having checked, I said also the fourth term. And then immediately thereafter, they wrote a letter.
If your lordship would permit it, maybe I'd stand down and get proper reasons from Mr. Mpofu as to how it came about. But he's requested the 22nd.
Yes.
Yes, ma'am.
And then to those that are going to appear in the trial. Who's going to appear in the trial?
It's the entire team. It's Mr. Mpofu, Mr. Masugu, myself, Mr. Kulu, and I think... And
I
Mr.
see.
Nkata.
Okay.
Yes.
All right.
Yes, madam.
All right. So what do you want to do? You want to stand the matter down and make inquiries?
I'm not too sure if that would help, my lord. I'm just trying to say, if your lordship is not amenable to the 22nd, then I may have to convey the message to the leaders. Or if your lordship is amenable to it, then we...
Well, the difficulty that I have is that the order previously granted was that these days should be kept open in August. Beyond that, I accept that wasn't part of the arrangement. But August was supposed to be kept open. Well, in fact, the whole of the third term. As regards next year, or the second term of next year, that I'm happy to entertain by way of letters, or a letter, simply setting out what dates council are not available, and I will then from that be able to fix dates. All right?
Yes, ma'am.
So what do you want to do now, Mr. Buthelezi?
My lord, I'd have to stand the matter down temporarily, even if it's for 10 minutes, just to speak with Mr. Mpofu directly, and
All
then
right.
I'll come back with a clear answer.
Okay.
Thank you, my lord.
Yes, I will in the meantime put the terms of an order together as well, which hopefully we can then deal with when I return. Obviously, again, with the holding date being the 1st of August, the accused will not be required to appear on condition that the date that the trial will resume, they'll be here. Okay. Yes, we'll take a short adjournment. Court will rise. Yes, Mr. Buthelezi, can I use that 15th?
As the court pleases, my lord, we
Thank
will
you.
continue with the 15th.
And you can provide a list of the dates that council might not be available in the second term of 2023 by the 8th of June. It's just over 3 weeks from now.
It will be form part of today's order, right, my lord?
Yes.
Thank you, my lord. We will. Thank you.
Okay. Yes, I grant the following order then in this matter. Paragraph 1. The trial is adjourned to the 1st of August 2022 at 10 o'clock as a holding date, pending the decision of the President of the Supreme Court of Appeal in respect of Mr. Zuma's application in terms of the proviso to Section 17(2)(f) of the Superior Courts Act 10 of 2013, I beg your pardon, 10 of 2013, and if unsuccessful, Mr. Zuma launching an application, if so advised, for leave to appeal to the Constitutional Court. 2, the adjournment is granted on the basis that if the application, in terms of Section 17(2)(f) of the Superior Courts Act, has been determined by the 1st of August 2022, and no application for leave to appeal to the Constitutional Court has been launched, the trial shall resume at 10 o'clock on 15 August 2022 and shall thereafter continue until 16 September 2022 and again from 7 November 2022 to 2 December 2022. 3, if the trial is not ready to proceed by the holding date of 1 August 2022, then a further holding date and date for the continuation of the trial shall be determined. 4, on the basis that the accused undertake to appear on the 15th of August 2022, if the trial is to resume on that date, Mr. Zuma and the representative of Thales are excused from attendance on the 1st of August 2022. 5, the counsel of the parties who will be representing the accused at the trial are requested by 8 June 2022 to provide a list of the dates of prior judicial commitments when they will not be available for the continuation of the trial during the second term of this court for 2023. And that is the order. May I just add in regard to the last paragraph that the list of dates that counsel are not available should simply be emailed to my registrar, please. I potentially also have a difficulty during that second term, but once I have the dates, then I shall correspond with the parties as to what we can agree upon.
As it please the court, my lord.
Court will rise.